And we are live here on Baldani TV. It is Attorney Bradley Clark, and I'm, as always, joined by my co-host, Abe Mashney. We are in downtown Lexington, and joining us today for the first time is my friend and a great lawyer, Nate Miller from Suhre Associates in Louisville. Nate, tell the people hello.
Hello, everyone.
All right, and we are here today doing Friday Legal Mailbag. And as it's Friday Legal Mailbag, we're going to answer your questions as they come in over the stream, and we're also going to answer some questions we have from some listeners that came in over the week. So without further ado, let's get it going. All right, and we are back. So we're here today, as I said, we're answering legal questions. If you've got any questions, by all means, bring them in. As I said before, Abe is going to be hooking us up with some certain questions he's got. Sorry for that brief pause, but we're now ready. So, Abe, what is going to be our first question today we're going to be covering?
So the first question is, what to expect during arraignment in Fayette District Court?
I'm going to give that to the new guy, Nate, or actually, I'll take that.
Sure.
So in arraignment in Fayette District Court, you're going to do a couple things. If your client's in custody, and I'm going to take this from a lawyer's perspective, what you're going to try to do is get their pretrial risk assessment in advance, and you're going to make an argument to get them out. Hopefully you're going to have family members there that can vouch for them, maybe an employer. If you've got proof of a job or proof of a place to stay, that's always going to help. Most importantly, you're going to try to get them out of jail. Now, if they're out of jail already, or you've already talked about bond and they're going to be getting out, the other thing you're going to be doing is entering a not guilty plea. Now, a lot of people get confused about this, and they think, they see the article in the paper that says, so-and-so pled not guilty to murder. Well, how can he do that? Well, the reality is that you almost always are going to plead not guilty. You're going to enter an automatic not guilty plea. And the reason you're going to do that is because you're going to want to get the evidence, and you're going to want to see. Nate, your phone, turn it down if you would. It's all good. You're going to want to see what it is before you choose to plead guilty, and your attorney can advise you on what you should do. But you're going to enter a not guilty plea, and then depending on whether or not it's a felony case or a misdemeanor, you're either going to ask for a preliminary hearing or a pre-trial conference. And both of those are really going to be opportunities to either try to work out the case or for the case to progress. And that's really the arraignment process. Am I missing anything, Nate? Is there anything you'd add to that?
Those are the basics. A couple of things that I always tell folks, it's the reason it's important to have an attorney and an arraignment is, especially on a DUI, there are a couple things that you would need to do if you have been charged with refusing a blood or breath test.
Oh, that's a good point.
You are entitled to, or at least pursuant to the judge's discretion, an ignition interlock device. You would have to waive your right to a refusal hearing at arraignment per statute to be eligible for that. Another reason it's good to have an attorney at arraignment is to preserve any evidence, like videos. Sometimes those things run on a 30-day loop. If you've been at the jail, at a hospital, police cruiser, lapel videos, those last two, the law enforcement videos, if they have them, are typically kept a little longer. But the pretrial is usually set about 30 days out. And if you have been in a parking lot, hotel, gas station that has outside video, that could be gone in 30 days, and you want to try and go ahead and get an order to preserve that.
Okay. Abe, do you have anything you'd like to add?
Y'all covered it.
Okay. What is the next topic that we've got going on over here, Abe, on our Friday legal mailbag?
So what factors do judges look for when deciding probation during sentencing?
Okay. Do you want to take this one, Abe?
Sure. So first and foremost, they're going to look at the seriousness of the crime. What were you found guilty of? What were you convicted of? Whether it was a jury trial or whether it was a guilty plea, the seriousness of it is going to be a huge determining factor of whether or not you get probation or you are sentenced to prison. Secondly, they're going to look at what type of family support you have, and those can be done by letters given to the judge prior to the sentencing hearing. They're going to look at if you have a job. Are you a productive member of society? Are you working? What are you doing in your free time? Judges love jobs, and so it's really important if you don't have a job between the case and sentencing, you get one. Doesn't matter what job it is, they just want you working.
Yeah, even if it's a minimum wage job. I mean, even if you're just cutting lawns, just something you can say, that, idle hands are the devil's playthings, as a lot of people say,
There
right?
you go.
And if you get in trouble, a good way to stay out of trouble is to get busy, and I think a lot of judges really appreciate that.
They're also going to look at criminal history, and while you can't change that, it is a factor, and so that's going to be included in your pre-sentence investigative report, also known as a PSI. And they're also going to look at if necessary or if applicable, a victim's impact statement. That is when the victim of the crime gets to write directly to the judge as well. And it could be as simple as one letter, or in a case I recently had, it could be 29 pages of letters. Also, they're going to listen to your attorney. And so that's your attorney is given the opportunity to file any motions for probation. I believe you just had one today where you filed a pretty lengthy alternative sentencing report. And so you want to talk about that?
Yeah, sure. So another thing that I think is kind of underrated, Chapter 532, the statute on sentencing in the Kentucky Penal Code, talks about alternative dispositions to prison. And everybody knows there's prison and there's probation, but there are alternatives in between too. Not everything isn't just slap on the wrist, you get out, you report, you drug test, versus you go straight to prison for 5 years. You can do a split sentence. You can be sentenced to county jail for up to a year. You can be sentenced to home incarceration for up to a year. You can be sentenced to have to complete a rehab or a therapy or meet with a counselor. You can be sentenced to really just about anything you agree to. One famous example I can think of, this wasn't my case, but it was in the state of Indiana. There was a death penalty case where the defendant's family promised to buy the small town a fire truck in exchange for him pleading guilty to life without parole. That seems a little bit unusual, but good attorneys are creative. And we think about how can we help the government get what they want, and how can we help our clients get the result they need. So I filed a motion today. In particular, it was a pretty bad case. It started out as a Class B felony punishable by 10 to 20 years. It would have been 85% of violent crime. And we were able to file an alternative sentencing plan. I'd already gotten it reduced down to a Class D felony that made it probatable, but ultimately our plan that involved therapy, it involved kind of some outreach to the victim involved, and we were able to get him 90 days in jail followed by probation on what started out as 10 to 20. And so it was a really good result for the client. He was very happy, even though he is going to jail for 90 days. Sometimes you have to make the best of two bad decisions, and he made the best of two bad decisions. And so I applaud him for that, and taking care of his problems. He went and got treatment, anger management, anxiety, all the things he was going through. And I think it really impressed the judge, and I think the judge really listened. And so a lot of people are skeptical about that, but I would encourage people to consider filing alternative sentencing plans, particularly in cases involving drugs or mental health issues. Nate,
Absolutely. Yeah, it's so important to get a good attorney that is able to do that and get to them early, because this is not stuff that can be done at the last minute. A lot of people walk into court like, oh, what if I go to rehab instead of this? And if you've got nothing to present, you've got no game plan, it just holds no water to even make that suggestion.
I would say finally, judges look at if the person was in custody during the pendency of the case or whether they were out, how well they did on bond. If you have multiple pretrial release violations, whether you tested dirty or you picked up a new case, it is extremely, extremely important to stay clean, stay out of trouble when your case is pending, because all of that matters, and especially the part between the conviction and the sentencing hearing.
Okay. Abe, what is our next question?
All right, let's just go to theft-related cases.
Okay.
Do y'all have any strategies that potential?
Well, the strategy in a theft-related case is return the property or pay it back.
There you go.
If they can prove it. Obviously, if the evidence is lacking, then the strategy may be different. And maybe even if the evidence isn't lacking, the strategy may still be the same. It really depends on how many prior offenses the person has. I think that has a lot to do with it in district court. But also, sometimes there are, like we talked about, alternatives. There are shoplifting, like prevention classes people can get in. Sometimes, theft can be a result of mental health. It's not just something that has to do with a lack of having access to funds. And I think that, everybody in the Lexington legal community can certainly think of a story along those lines. And I've had it before, too, where I've had people that were very privileged and could have bought everything that was in the bag, and they just walked out with it. And there are certain, types of obsessive compulsive disorders that can cause people to steal. So don't just think somebody's a thief because that something bad happened. And also sometimes there could be really mitigating circumstances. I had a client who had gotten emergency custody of her grandchild because her daughter was going through some drug addiction problems. And all of a sudden she had all these additional responsibilities, and she made the very wrong decision to, kind of to take some money from work, but ultimately we were able to get in and pay it back, and she was able to get a diversion agreement. And so I think that really the thing in theft cases is the ability to pay it back or the ability to make it right are very important. Abe, do you have anything?
Well, I would say this, that you're 100% correct on the ability to pay it back. The biggest question, I think, is when you can pay it back. And ideally, it's going to be as soon as possible. But what a strategy that I've used countless times is continue the case for as long as possible if there's an issue of paying it back, because you're going to get a much better deal usually if you are able to pay full restitution prior to the disposition of the case. So prior to pleading guilty or prior to the case getting dismissed, prosecutors aren't going to dismiss a case or give you a really good sweetheart deal if on the promise that, oh, well, I'll make payments for 1 year and I'll eventually pay it off. No, they want to see it paid off in full upfront before you do anything with the case.
And I'd just add to that, sometimes if you can pay it off before it's even charged, that'll make a huge difference. So, Nate, do you have anything to add?
Yeah, that's extremely important, the ability to pay. This kind of goes back to what we were talking about earlier, having a job. Another good reason to have one is you're able to pay back restitution. If you're in jail, you're not going to be paying back much of anything while you're in there. However, if you can come up with the money up front, that keeps the prosecutor in good graces with the vendor or whoever the alleged victim is in the case, and it also gets it off their docket and it gives them the opportunity to settle it quick, which all prosecutors like to do.
If you're talking about strategies, well, strategy number one is I didn't do it. And
I guess there is that side to it too. Yeah, have either of you guys ever tried a theft case?
I have not.
They tend to work out. I don't believe I have either. There's, like you were pointing out earlier, there's all kinds of different
reasons,
cases, and reasons. So, are we talking about the guy who was walking around Walmart drinking a soda pop and eating chips and was charged with theft? I've had that case. I've also had the case where somebody's in a store like Macy's and they are accused of using a lookout, and there's something more elaborate. There's more expensive merchandise at stake. So, depending on the type of case, where it's at, the vendor, what county it's in, those are all factors that come into play, and your attorney needs to know how to handle each one.
I got really close. I had a trial scheduled, and it ended up being dismissed the week before. It was we were ready to go. It was a case where his wife and him went into a convenience store, and one person took it, the other person didn't. They charged them both, and I represented the person that didn't take anything, and so we were ready and willing to go to trial, but they lumped them together and thought that they were conspiring, and they knew what was going on. And so by putting the feet to the prosecutor's fire and just say, hey, we're gonna try this, and they ended up backing down and doing the right thing.
Yeah, I actually ended up trying 2 of them. I think that you're more likely to have them as a public defender than you are in private practice, just because it goes back to that ability to pay. You're going to get a better result, and a lot of theft does result from poverty, so it's going to be more like of a public defender case you're going to see, unless you're really getting into like kind of white collar or employee theft, which I've had a good bit of that lately too. But I tried 2 cases. One was a not guilty, one was a hung jury that eventually resulted in a not guilty, and both of them, one of them, the evidence just wasn't there. Like the video didn't establish what they said it established. They couldn't prove that the property that was in her purse actually came from there. And then the other one, I think the guy actually legitimately was innocent, and he was a victim of kind of some racial profiling. He worked as a custodian of a major department store. I don't want to slander the one. I can't remember which one it was, but and the over kind of zealous loss prevention guys had seen him on the video picking up stuff that was like really ostensibly trash. Like there were like cologne and perfume testers that were on the floor that he picked up and put in a bag. And his whole thing was, look, I was going to take it back to the front desk because I didn't know where to reshelve it because it was an interesting display. And he didn't even make it out of the store. He just had the bag, and he was walking toward the exit, and they stopped him. And that one was a pretty quick not guilty, as it should have been, because who steals cologne testers? What are you going to do with that? But that one, That's one that really sticks out in my mind, and I can't believe we actually tried that case. But sometimes, it happens. So that client was actually an undocumented immigrant, and he was facing deportation had he been convicted. So.
But before we leave this subject, and I'm curious to get your guys' thoughts on this, some of the more serious theft-type offenses are not misdemeanors where you're talking about a store, but I've had theft of services and theft by failure to make required disposition, which is essentially, as I have experienced them with my clients, look like a contract dispute. You get somebody coming in, supposed to do some work, maybe construction, pour a concrete slab, they started, there's a disagreement, they part ways, and rather than the alleged victim going to civil court, it ends up in criminal court as a theft charge. And I'm curious to know what your guys' thoughts are on those, because I had a lot of those as a public defender.
Yeah, so what we're talking about, I guess, are cases where they could have been filed in civil court, but they end up getting filed in criminal court. And yeah, I mean, I think that we don't like them, and prosecutors don't really like them either. Ultimately, it's kind of an abuse of the system. Like, unless you can prove, and the difference between what is a contract dispute and what is a criminal charge all goes down to mens rea, right? What the person's intention was. And in a civil case, we're not really concerned with why am I out this money. It's just that you're out this money and the other person's the cause of it. They broke the contract, they did whatever. But in a criminal case, the government has to prove that you had bad intent when you entered into the contract or you entered into the agreement, that you never were going to do it, basically fraud.
Permanently deprive. Not only,
and that you intentionally did it, right? So if me and Abe, Abe contracted with me to build him a brick wall, and
bad idea.
You don't want that from me. But if he did, right, and then I fell ill and I wasn't able to complete the wall, I didn't steal anything from him, right? Now, granted, I would owe him the money back because I didn't deliver on my side of the contract, but that didn't mean I was a thief just because I became ill and couldn't build the wall that day. Maybe bad time to talk about that. But in any event, when you get those cases, I think it's important to harp on it and say, like, look, I mean, there's just no proof that my guy intended to do this. Your victim may be out some money, but it's a civil matter, and we're going to try to pay it back. This is how we're going to pay it back. And I think a lot of prosecutors are receptive to that. They don't want to. They're not some sort of collections agency. They're not supposed to be public defender equivalents for contract dispute plaintiffs' lawyers. So
politics can get involved sometimes, though.
Oh, absolutely. Yes.
Absolutely, depending on who was allegedly wronged.
I had one recently. A well-known country club here in Lexington was trying to recover on a default member's dues, and which should be a civil case, somehow managed to be a criminal case. And thankfully, we were able to have a very good judge who did the right thing and rightfully thought it was a civil case. And this is the restitution had all been paid prior to even stepping foot in court. And so, again, politics.
So you were able to get that dismissed in circuit court?
It didn't even get to circuit court.
It got dismissed at the preliminary hearing, actually, for lack of probable cause, for lack of intent. And
very
then
good. Very good. Bravo.
They appealed it, and then...
Oh, wow.
Anyway.
Sure. Well, kind of going back on, this kind of brings me to the next point. The criminal, civil, debt collector, that theme. Have any of you all, because I have, any of your clients received a letter?
Oh, Abe, can I stop you before we get to the next question?
Sure.
I just wanted to remind everybody out there watching that you can always like us on the Facebook, and you can watch the ticker tick up. And if you haven't yet voted on Abe's beard, right now, yes is winning 2/3 to 2-3, or 2-1, I suppose.
I'm one of those. So.
Oh, Abe likes his beard. One other person likes his beard. Another person said no. So if you don't like the beard, or you do like the beard, I'm going to encourage you to go out there and like the beard. But more importantly, like us, like Baldani Law Group, and go like Suhre Associates, Nate's firm in Louisville. They're great people. So anyway, I'm going to let you get back to yours, but I wanted to kind of remind people.
All right, theft-related. Here's the situation. Theft-related case. Client steals or allegedly steals from one of the big box places like Kohl's, Walmart, Macy's, Dillard, one of those places. A criminal charge is instituted. They didn't technically steal anything. They didn't walk away with anything because they were caught by loss prevention before. So the store is not out anything or any product. They get a letter from them saying, you owe us $250, you owe us $500 because of this, and here's the statute. It's KRS 411.095, and this gives them authority. It's usually a debt collector. Has any of y'all had this issue come up? Okay. What would you say in that situation?
Let's go to Nate. Nate, what do you think? What do you tell your clients?
Pay it if you can. I mean, it really depends on the situation, I suppose, and I'm not sure if I'm entirely understanding what you're asking.
He's talking about your client gets a civil demand letter from the department store to pay statutory damages.
Then it would be the opposite of that. Don't pay it.
Agree.
Yeah.
Yes.
Yeah, I mean, okay, so like, look, technically you could be sued for this, right? If they can establish the elements of the tort, meaning the civil case. Are they likely to be able to establish that? Are they likely to even waste the money to get $500 back? Absolutely no. So unless you feel some sort of moral obligation that you violated the statutes of Kentucky and therefore you should pay this department store this money for something that they got back, the answer is no. I mean, they can, from a legal strategic point, you don't, just because you may have violated a law doesn't mean that you have to pay a demand letter. And you may have legitimate defenses to it, and ultimately the amount that they're seeking is so low that they're extremely unlikely to ever proceed against you. That being said, ask your lawyer if you receive one of these.
Yeah, what I tell my clients is if and when they receive the letter, just give it to me. What I end up doing is writing them a letter, whether it be the company itself or the debt collecting agency that they've used to try to obtain the funds. I essentially say, I'm advising my client not to pay this. If you have any questions, please give me a call. And magically, I've never heard anything back after sending that letter. So it's a
numbers game. For every 1,000 letters they send out, if they get one person to pay, then
people have definitely paid it. Yeah.
Oh yeah,
and it's worth sending those letters out.
100%. Yes, and it's a situation where they are already in a fragile, in a nervous state, and they don't want to. They've been apparently caught, and they've got a pending criminal case going on, and they are doing anything and everything to get out of trouble, and they feel as if they need to do that, they have to do that, but in reality, they do not.
Okay, yeah, no, and just one other thing I would say is it could be construed as an admission if you did pay it before the criminal case is over.
Agreed.
So absolutely, I would advise no one to ever pay this, even if they feel a moral obligation, until the criminal case is over and it's been adjudicated.
Good point.
Next question?
Sure.
All right, so domestic violence charges and the right to own or possess a firearm.
Okay, yeah, I guess I'm probably the one on this.
Sure.
All right, so the question is, if you receive a domestic violence charge, are you allowed to possess or own a firearm? And the answer is not if you're convicted. So assault fourth degree and all crimes of domestic violence that involve contact, and in which you actually allocute, meaning which you actually plead guilty to having had a domestic relationship that as qualifies under it's the Violence Against Women Act, or the Federal Violence Against Women Act, will prevent you from owning guns and ammunition. And in fact, one of the things that most courts do if someone pleads guilty to an act of criminal domestic violence is they'll make you sign a form, and they'll even make you set up with the sheriffs to come retrieve any firearms from your house. The same is true if you have an active emergency protective order, interpersonal protective order, or domestic violence order out of a family court or circuit court, depending on what jurisdiction you're in. Those also can prevent you from possessing a gun under the federal law. Now, you're not going to be prosecuted in state court. It's not necessarily a violation of state law, but it is a violation of federal law. And so you're not going to be able to pass a background check. You're not going to, if you get caught with one, you can be prosecuted in federal court, and I've seen it. So this is serious. If you are charged with domestic violence and you are an avid hunter or a hunter at all, or you care about home protection with firearms, you need to take this very seriously, because the way that one small part of your plea, you can plead guilty to assault fourth, meaning the lowest level assault, and not have it be domestic violence and not trigger these protections. Now, is there a way to reverse this? There is. With an emergency protective order, interpersonal protective order, domestic violence order, any type of restraining order, that's eventually going to expire. They can only be issued for 3-year terms. They can be renewed, but once it expires, you're eligible to possess a gun again. And then if you get an expungement, the federal law actually allows for someone that has an expunged conviction for domestic violence to go back and then be able to get a firearm. And the time limit on that is going to be 5 years after you complete your sentence in Kentucky.
I've had an interesting issue come up and had upper court agree with me on this, but there is some conflict with state and federal law. The federal law's wording, I'm not exactly sure, and one of y'all might be able to help me on this, but with the prohibition against having firearms, it's if there was a domestic dating type relationship.
Yeah, there has to be.
So in the context of an interpersonal order, which can be
Sure.
between me and Abe or me and Brad, I have had a judge mistakenly order you can't possess firearms after a finding that there was reason to enter the IPO. I appealed that and pointed out that federal law requires there to be some sort of relationship, and that is Kentucky law is kind of silent on the issue, but federal law is very clear. So.
Right.
That is a good point. Yeah, no, and particularly in the civil context of restraining orders, I think that some of that stuff is unclear. We don't know for sure. But definitely if you have that domestic violence relationship that satisfies the federal law, which is a little bit different than our statute too, you're going to be subject to this ban, and you shouldn't possess a firearm unless, it's been cleared by your attorney and ideally the, CJIS, at the FBI, the people that do the background checks. So do you have anything to add, Abe?
I would say that if you are charged and convicted of assault fourth domestic violence, which is a misdemeanor, you would lose your right to possess a gun while that conviction still stands under the federal law. However, if you can get it expunged after the statutory time ran, you can possess a firearm after that time.
Yep, that's right, under state and federal law.
There you go.
So what do we have next?
Last question.
We're coming up on our 30-minute deadline.
All right, so it's going to be about marijuana DUI.
Okay.
And we have Nate here to talk about it.
Yeah, so Nate, you've recently posted an article on Facebook about marijuana DUI. I guess the first question I'd have for you about marijuana DUI is, what's the legal limit for marijuana in Kentucky?
There is none. The state is required to prove that you are actually impaired to drive. Marijuana is not one of what's called the zero-tolerance drugs. So in the statute that deals with DUI, there is a list of about 12 drugs. If you have any level at all in your system, you are per se guilty of DUI. Per se meaning that the prosecutor doesn't have to prove that you were driving bad or the field sobriety tests were really that bad for you, but this was in your system, just like if you had a .08 BAC. So zero-tolerance drugs doesn't matter. If they're in your system, you are presumed to be guilty of DUI. Marijuana is excluded from that group of 12 drugs, meaning that they would still have to prove that you were impaired, and they would have to do that through the officer's observations and or the level of THC that's detected in your system after a blood test is given. Kentucky does not have a presumptive level for THC like it does alcohol. Some states do. They set it at around 5, 4, 3 nanograms per milliliter. So it's important to, if you have been charged with marijuana DUI and you do have a level, and I'm not talking about, sometimes they'll show what's the metabolite of marijuana.
Have you seen a urine test ever?
Never.
Okay.
No,
and that's good.
Yeah.
They shouldn't do urine tests.
I think there's Kentucky case law, Burton, to basically deal with that, and urine is no good really for purposes of proving impairment. You need blood; it's much more reliable, but you also need a level. So if you've got metabolites or you've just got the presence of THC, I don't think that's enough to convict. They've got to have a toxicologist come in and say, we detected 15 nanograms per milliliter of blood in Mr. Smith. That is enough to be considered too impaired to drive. That's what has to be proven, I think, in order to sustain a conviction in Kentucky at this time.
Okay, and that involves blood necessarily.
Blood,
Yeah.
yes.
Which bumps up into a whole lot of other constitutional concerns that are probably beyond the scope of what we're talking about today. But
Absolutely. Yeah.
Let's talk about what is it?
DRE,
DRE?
drug recognition expert. So this is one of the ways that the state might use to try and prove that you are under the influence of, let's say, marijuana. A DRE is someone who's been to a pre-course about 7 to 10 days called ARIDE, Advanced Roadside Impaired Driving Enforcement, and then they could do another more thorough course, DRE course. I think that even requires like 40 hours of field time after another week or two long class, and it is a series of questions and tests that they would put you through to determine whether or not you are under the influence of drugs. I know people have looked at this and they think that it's kind of shoddy science. Voodoo science is a word I've heard tossed around a lot. So if you have a DRE in your case, and there's not that many in Kentucky. Kentucky was actually one of the, think about the 6 states that had the DRE pilot program, and the folks that were trained here were vehicle enforcement. Since then, some Kentucky State Troopers have taken the class.
They'll do some of the modified Romberg
But
test.
there's still not that many officers here in Kentucky that are qualified to go to court and testify that you are under the influence of drugs. And this is important because the standardized field sobriety tests that every officer has been trained on are tests that were approved for detection of alcohol impairment.
And they were tested in a lab environment to determine and validated, presumably under certain circumstances. Unlike these tests, which are just, we think this works.
Right.
Right. I've seen in citations where they will give the results of standard field sobriety test, horizontal gaze nystagmus, walk and turn, and then they put in parentheses associated with marijuana. Like, so that officer felt that result directly corroborated a marijuana impairment. How he came to that result, I have no idea.
And it's impossible. If you read the training manuals,
Right.
the HGN, the horizontal gaze nystagmus, is good for indicating impairment by 3 substances: alcohol, PCP, and inhalants. That's it. Not opiates, not marijuana, not cocaine, nothing. But we see it routinely on citations used to prosecute clients for being under the influence.
Okay, so that's it. It sounds like to me we don't have a really good way to detect marijuana DUI at this point other than blood, and there's all sorts of problems with that too.
What I have heard from experts in the field is that the most accurate, reliable test that shows recent or indicates recent use and impairment is actually saliva, not blood.
I had to kind of follow up with that, I had an officer one time claim that my client's tongue was green, and that's how they know they'd smoked marijuana. Have you ever seen that before?
I have. It's ridiculous. I like it when they write it on there because it shows they don't know what they're talking about.
All of you guys out there in the comments, let me know if your tongue has ever been green from smoking marijuana in a legal state like Colorado. Anyway,
don't do that.
Don't put it in the comments.
Yeah.
Anyway, I think we're done for today. Do you guys have any final thoughts? Anything you want to add, Nate?
I want to thank Abe and Brad for having me on in the Baldani Law Group. This is a great location, man. I'm glad I came by today and saw your new place.
You're welcome anytime.
Thanks, man. Yeah, and we'd like to thank you for coming out too, man. Like it's great to have guests. We're set up for 4 people. If you want to come on, lawyer, not lawyer, whatever, let us know in the comments, and we'll try to get you in here to talk about things. I'd like to thank once again Nate from Suhre Associates. If you do happen to run into trouble in Louisville, Northern Kentucky, Cincinnati, they've got offices there. They do great work. But if you can't get into trouble in Lexington, you know who to call. Anyway, I'd like to thank everybody again for watching, and we'll see y'all next week. Hey, you got 80% beard.
Nice.
It's cheaper.
Let's see what the wife says.
Well, we had pretty good viewership. I think that was our best ever.
I agree. I think it was like
7 or
12 at one point.
Oh, was it?
Solid, yeah. And then I caught it as 2, and then I caught it as like 4, and so it was good.